My name is Ken Ross. I am on the board of SPSB and am the webinar coordinator for SPSB. I want to thank you all for attending today. This is our third webinar this year. We've got at least 8, maybe 9 more webinars through the end of the year. And this year's webinars are being sponsored by Sedgwick Brand Protection. And we thank Sedgwick for their sponsorship this year and in prior years. And thank you all very much. The material we're going to talk about today, these slides and additional reference material will be posted on the SPSB website for you to look at, or for others in your company or anybody you want to show to look at this material. So some of this material, particularly near the end, we may go over quickly. We'll assume that if we don't have time to get to in detail to talk about these things, that you'll be able to look at these things later on. And we'll have our email addresses there if you have questions about the material that we've talked about today or the material that we're going to be posting. Okay, let me introduce, let me just get a second here and get the slides. Oops, sorry. Okay, so the speakers today are myself. I'm going to participate here at the end, but our main speaker is Dan Harris. Dan is a partner in the law firm of Harris Slowowski, LLP in Seattle. And Dan is the guy I always go to when I have China questions. But he is a leading authority on legal matters related to doing business in emerging markets. And he has written extensively and lectured extensively on international law with a focus on protecting businesses in their foreign operations. And that could include a company that sells products or services to foreign companies, wherever they are in the world, or companies that are buying products and services from foreign entities. So it's either inbound or outbound kind of international activities for companies. I will also be speaking, and I've been an in-house lawyer for a number of years, and then an outside legal counselor in product safety and regulatory compliance. And I have also done inbound and outbound kinds of activities. And I've counseled many foreign manufacturers on how to sell their products in the US. I get lots of questions from them about whether they have a big litigation risk or regulatory risk by selling their products in the US, and I can do a legal audit for them on their products. And there are many, many companies that just are reluctant to sell products in the US because of what they perceive to be the high legal risks of doing so. But I also represent companies who buy products, either finished products or components, from foreign companies and have safety issues or product liability issues, regulatory issues, and how do we deal with those? So I've got experience on both sides of this. So let's talk about the topic we'll talk about today. Now, most companies buy products or components from foreign manufacturers. They might own a foreign plant, or they might contract with a foreign manufacturer to produce the product. Now, this raises significant legal risks if problems arise. The foreign manufacturer may not have a legal presence in the US and may not have US-based insurance. And these components or products could create legal problems, from warranty issues to personal injury claims to CPSC issues, which involve potential or actual recalls. So the first question is whether it is prudent for you to buy a product or a component from a foreign manufacturer. Now that deals with the question of, is this product or part safety critical? So I like to narrow down the focus and make sure not overwhelm a client by having them examine every part or every product that they buy. But is it safety critical? So what happens if it fails? That's during your design process. That's the kind of analysis you're going to do anyway. So if it's safety critical and could create safety/legal problems, then we pay more attention to it. And now you have the same risks if you're buying safety critical parts from a US-based or a North America-based company, but it's different because they're in a foreign country. And Dan's going to talk about those risks. Now Dan's going to talk about contracts, due diligence, quality control. Now, as product safety professionals, you may not be directly involved with negotiating contracts, but I encourage you to be actively involved in helping those people in the procurement department, the purchasing department, understand what risks there are in whether this product is going to be bought in the US or bought in a foreign country from a foreign manufacturer, and what should the company do to minimize the risks or protect the company in the event there are problems. So whether you're a design engineer, whether you're in quality, you know more than the people who are buying these components and products about safety, quality, and the problems that could arise if there are problems, failures after the product is sold. So you can be helpful in deciding whether it should be purchased from a foreign manufacturer or not. And if it is purchased from a foreign manufacturer, what kind of enhanced quality control procedures should you employ to be sure that everything that you receive from the foreign company is compliant with specifications, is safe enough, is installed correctly, or is advertised, marketed correctly. So there are a lot of issues that arise which you need to consider when doing these things. So while you're not presumably negotiating contracts, you should be actively involved in helping the company identify the risks and figure out how to minimize those to the extent the company would like. Now, there are different scenarios that are involved here. And whether you're buying a product and there are just many different permutations of how this can happen between designing, manufacturing, branding, licensing, and a big difference between if you buy a finished product from a foreign company, even if your name's on it, or you're buying a component part and installing it in your product. That's different too. So just think about this. This is not just one fact scenario that we have. There could be many different ones, and that's what makes this area fairly complex. And you really need to think through what you're doing, what's appropriate to do, what kind of relationship do you have, and that's going to help you then figure out about the contracts, the due diligence, and the quality control that Dan is going to talk about. Okay, with that said, that's my introduction. I want to turn it over to Dan Harris, who is going to talk about these issues I just mentioned. Go ahead, Dan.
Thank you, Ken. Hello, everyone. Good morning, good afternoon, and good evening. Before I get to the heart of my talk, I'm going to throw out three hopefully relevant tidbits. The first is that long ago, when it was legitimate to call me a young lawyer, I actually did a huge amount of product liability work. And it was actually through product liability. I represented a big Australian company that I transitioned into international. The second tidbit is that I'm going to be focusing on product liability risks, product safety risks today, but probably 90% of what I'm telling you reduces risks overall. In fact, I use a very similar slide deck for a talk I give on protecting your intellectual property. The keys are oftentimes overlapping. And the third tidbit is that I'm going to be focusing on China today whenever I focus on a particular country. And I'm doing that for two reasons. One, China is obviously a huge and primary country for product outsourcing. But also China's pretty representative, meaning a lot of countries in Asia have taken Chinese laws as their own. And the reality is, at least 90% of what I say here today holds true throughout the world. It would hold true if you were getting your products from, let's say, the UK or Germany. These are basic tenets of protection. Next slide, please. So I always say there are three keys to ensuring you have good products. Number one, good partnership. Number two, good contracts. Number three, good QC. I often tell people we could write the world's best contract, but if your provider is a crook, it's not going to have any value. And you would be surprised, or maybe you wouldn't be, how often companies come to us with a problem with their supplier overseas, and I'll be doing a Google search of that supplier while talking to them, and there'll be all these terrible things written about them. And probably 40% of the time when we research that supplier, the supplier doesn't even exist. It is a broker. I mean, we've had circumstances where somebody's buying a product in China thinking they're dealing with a Chinese company when they're actually dealing with a broker in Vietnam or India. So you really have to know who you're dealing with. That's square one. Good, and then good contracts and QC follow. Next slide, please. So how do you know who you're dealing with? You do your due diligence. It's not that tough. We have a program, we charge $1,500. We gather up a report on a Chinese company, a Vietnamese company, an Indian company. It's like a Dun & Bradstreet, only a little bit better. It makes sure they exist. That's important. It makes sure that they're licensed to do what they say they're doing. In most countries, that's required. If they're not licensed to make your widgets, there's something going on there. It also tells you, gives you some idea of what assets they have, what sort of intellectual property they have, and also it tells you whether they get sued a lot. Is it the be-all, end-all? No, but I think it greatly reduces people's risk, and it ends up disqualifying maybe 5 to 10% of the companies we look at. So in doing your due diligence, there's some things you can do. Don't trust the company information. It could all be fake. I'll highlight that in a minute. Go there. I know it's difficult these days, but it's really important. You are the knowledgeable people, not your lawyers. I had a client who went to 4 factories in China. This was years ago. A pretty big company, and there were about 5 of them gathered around. They described the 4 factories to me, and they said to me, which should we choose? And I went into a 5-second panic thinking, how am I supposed to know? And then I realized, do the old lawyer trick and turn it back on them. And I said, which would you choose if all these companies were in Peoria, Illinois? And they immediately picked one. I said, well, that's the company. Let us research them. And then at the end here, I try to get a little zen by saying delegate, do not delegate. Meaning get the experts to help you on anything you don't know, but don't have your lawyer look at the factory for you. You know the factory. And just going there and looking, I have clients who tell me they can walk into a factory and in 1 minute, they know whether they want to do business there or not. So do that. Next slide, please. Okay, I stole this from a client of mine who's a China manufacturing consultant. He shows this with pictures that he actually took. I pulled mine from the internet, but it still holds true. This is what every factory looks like on their website. Next slide, please. This is what it could look like in real life. And I've definitely had clients who have experienced this. And as I said, our consultant client, he used real pictures. Next slide, please. Okay. Make your manufacturer your friend. That's one of the advantages of going and visiting. Develop a relationship with them. Invest in quality control and testing. These things probably sound obvious, but the friend part is really important, meaning that if you're a human being to your manufacturer, the odds of them sliding in a cheaper material go down. I've seen this. Try it. Next slide, please. Okay, this is an overarching principle that I believe is important in doing business internationally, where the legal systems are not as strong as, let's say, the United States. Structure your deal and write your contract so your partner believes it will make more money with you than without you. When we see our own clients get in trouble, 2 or 3 times we've had clients who we have felt pushed the manufacturers too hard, meaning they'll do a deal that says, we're going to buy your widgets for $5 and you have to keep that price for the next 5 years. And the desperate company in China takes that deal. And then when the price of nickel, which makes up 25% of the product, rises by 50%, what does that company do? They don't go back to the American company and say, hey, can we raise the price because the price of nickel went so high? They substitute something for nickel and you get a bad product. Squeezing your manufacturer is not a good idea. And we're always suspicious of our clients who brag about having done that because they are setting themselves up for trouble. I'm not saying don't get a good price, do get a good price, do get a fair price, but be cognizant of not ruining setting up your manufacturer for ruin, because you're both going to go off that same cliff. Next slide.
Well, Dan, you could also you give them enough price for them to make a profit, but later on they would like to make more profit, so they substitute the material. And I don't know if you're going to get into this in quality control. How do you prevent them from switching material on you without you knowing about it?
Well, there's no 100% solution. In our contracts, we have 2 provisions that I would say sort of fit that bill. One that we have is you cannot subcontract out without prior written approval, because we have found that subcontracting causes problems. And we also put in there, you cannot substitute products. We have the material sheet. And then what we put in most countries, it's a very good idea to have a damages provision so that you don't have to go to the court and say, this caused me X amount of damages. You want a provision saying, and if you do that, you owe us $100,000. Because surprisingly enough, in a lot of countries, including China, you put that in there and that $100,000 is a floor and not a maximum. And that no subcontracting provision, people ask us if that works. And I can tell you that we have never had it not work. And I'm convinced that, I call it the bike lock contract, the bike lock theory of international manufacturing law. Your bike lock's not the greatest thing in the world, but if you have a good bike lock, your bike is probably not going to get stolen, because the thief is going to steal a bike with a lousy bike lock or none at all. The same is true with the no contracting and even the no switching material provision, because what happens is Chinese companies get busy, Chinese companies start having financial problems, so they start doing the switch around. However, that factory that's making your widgets is also making widgets for 40 other companies, and only 3 of them, counting you, have a provision. And these Chinese factories aren't stupid. So if they're going to send their manufacturing down the street because they're busy, they're not going to do it for all 40. They're going to do it for 10 of them, and they're going to do it for the 10 that don't have a provision that puts them at risk. So I say these are not guarantees, because the only guarantee would be to have 5 people in the factory monitoring every second. But these things can be highly effective, and they're very worthwhile. Great question. Thank you. Next slide, please.
Oops, just a second here. All right.
Okay, so here are the common manufacturing contracts. I'm not going to go into them, but these are the 4 biggies, the ones we do the most. One is an NNN agreement that says you can't make our product and sell it to someone else. Believe it or not, in most countries, if you don't have that provision, it's 100% legal. People come to us and say, my factory's making my product. What can I do about it? I say, send me your contract. And then I tell them nothing. Product development contract, that's helping them, the contract dealing with the development of a product. So you make sure it's yours at the end. Product ownership, you want it clear that you're going to own the product at the end. And then manufacturing, that's the big one that lists everything, delivery dates, quality requirements, etc. Next slide, please. Okay, people often say, why bother with a contract when, you know, it's India, they don't enforce contracts for 10 years, or you can't get a hearing in a court for 10 years, or it's Cambodia, it's unbelievably corrupt. Well, all that's true, but that's sort of the American way of looking at a contract. You're looking only at enforcement of the contract, and there are two other reasons to have a contract. One is clarity. You're dealing with a country, with a culture completely different than yours. And with China, we see this all the time. Somebody will come to us and say, my Chinese factory says they can get me the product in 2 weeks. So we'll put in the contract 2 weeks, every day you're late, 1% damages. Chinese company comes back, says, we can't get it to them in 2 weeks. It's going to take 6 weeks. And then our client says, well, why'd they say 2 weeks? They said 2 weeks because in China, you want to agree with people, and they're saying, yes, it's possible. We can get it to you in 2 weeks. They're not signing off saying, we will get it to you in 2 weeks every time. So having a contract in Chinese, for instance, brings clarity. It also brings prevention, meaning that the example I gave with the subcontracting, having that provision is very powerful for preventing problems. And when it comes to enforcement, let's just say, if you don't have a contract, you don't have enforcement. I'm not saying that a contract is 100%, but it's a lot higher than 0. And the big thing is prevention. Because no matter where you are in the world, once you have to sue, you've basically already lost. Next slide, please. Okay, why bother with a contract? What about corruption? Even in the most corrupt countries, the legal systems work to a fashion. The story I always tell is, we had a client owed $2 million by a company in Vladivostok, Russia, which makes China, which isn't really very corrupt, actually, makes China look not very corrupt. It makes even Cambodia look not very corrupt. And a Russian lawyer, friend of mine, know very well, he said, there are 15 judges in Vladivostok, 9 of them are corrupt. Of those 9, 8 of them are honest. Corrupt but honest. I go, what's that mean? He goes, well, it means if you pay them $50,000 to throw the case for you and they end up not being able to throw it, they'll return your $50,000. So we had a case in Vladivostok, $2 million. If it had been in the United States, we would have settled it. I'm making up the numbers here because who really knows? We would have settled it for 1.9 million. It was a slam dunk case. We brought the lawsuit in Vladivostok. We got a corrupt judge. We ended up settling the case for 1.6. Why did the Russian company pay 1.6 when they could have just bribed the judges? Well, I'll tell you why. Because they would have had to bribe a judge in Vladivostok a lot of money. They would have had to pay a lot of money because it would have been pretty clear that the judge was flipping the case for money, because it was pretty much a slam dunk for us. So let's say they would have had to pay that judge $100,000. Then we would have appealed it to Khabarovsk and gone in front of 3 judges who they probably don't know very well. So now they're taking a risk of going to jail. Not that the risk is very high in Russia, but there's some risk. And how much are they going to have to pay them? Maybe 300,000, 100,000 each. So now they're paying 400,000. We could even appeal to the Supreme Court. I don't know. But the point is, just because there's corruption, Americans think that it's like a computer switch or an on-off light switch. No, it just means your case is less valuable and the settlement value is less. It doesn't mean you have no case at all.
Let me just throw out, if you're selling products in a foreign country and you need to pay somebody something in order to have your products sold through the particular retailer or put on shelves or things like that. And this is a completely different subject than what we're talking about today. You got to worry about the Foreign Corrupt Practices Act, which I've had dealings with before as an in-house lawyer when we tried to set up a sales office in a foreign country and we had to buy off the phone company in order to do that. So that's a whole separate subject, but it's also, as we're, because you're talking about corruption. So when we talk about those kinds of things and buying off people, we need to worry about things much broader than just product safety and product liability.
Absolutely. Although interestingly enough, in a lot of countries, you legitimately do have to pay, like in China, even in Korea, you have to pay the department stores to get your product in, and that's completely legal. But what you said harkens back to the day when I was in high school. I lived in Turkey with my family for a year, and in order to get a phone, we had to pay $50. Otherwise, we wouldn't have had one the entire year we were there.
I think we had to pay $1 million to get our phones set up in some Middle Eastern country of some sort.
Right.
Yeah.
Okay. Next slide, please. Okay. So what's a good contract look like? Some of this is pretty obvious. It should include provisions for quality control, factory inspections, product testing, and liability. Put in anything you want. It doesn't mean it's necessarily going to work. And there are times where we remove things from contracts because it's that people give us because it's confusing. But most of the time it makes sense. Require your manufacturer to obtain insurance to cover any product claims. Yeah, maybe. I'll turn to that in a minute. Have a contract that's clear about subcontracting because that's oftentimes when product problems arise. Next slide, please. Okay, hope versus reality on product liability insurance and indemnification. We have clients who think, I've got a great contract with my Chinese manufacturer. It requires that they have product liability insurance and it requires that they indemnify me. And then I say to them, have you seen the insurance policy? Do you know whether this tiny factory that's making your rubber duckies can afford a $20 million recall? And they look at me like, well, what else are we supposed to do? Well, I'll tell you how this works. With Chinese companies, Vietnamese companies, Cambodian companies, you're getting, and I'm using this loosely, you're getting the China price. And if you want them to buy real product liability insurance, you're not going to get the China price because it's going to cost them, and of course I'm making this up, $3 per widget. And then they're going to add that $3 to you. And if they're going to get real insurance and charge you $3 a widget, maybe you should get your own insurance and pay $3 a widget, because otherwise you're going to have to take that Chinese insurance policy, and we've done this for people, and have it analyzed by somebody who knows Chinese and knows the Chinese insurance industry. And that is not cheap, and that is complicated. And indemnification, sure, put that in your contract, but I wouldn't necessarily rely on it, because most of these companies in places like China, Vietnam, India, they do not have much money. Their profit margins are thin and they don't have a lot of money. So generally the safest thing is getting your own product liability insurance. Next slide, please.
And recall insurance, possibly.
And recall insurance, that too. Okay, what else should be in a contract? It should be in writing. And by writing, I don't mean email, I don't mean purchase order, I don't mean invoice. In a lot of these countries, especially China, those things are almost meaningless. You need a contract, old school contract. The contract should be in one language. I don't know what it is with these people who think, I'm going to compromise. I'm going to have the contract be in both Chinese and English. Those are both the official language. So I was speaking at a bar event and I said, I don't know why lawyers go along with this. And someone raised their hand and said, I know why they go along with it. We make triple if there's ever any litigation or arbitration, because there are three languages. There's the foreign language, there's the English, and then there's the combination of the two. And we did have a case with a company who had a dual language contract. And I do think that their arbitration costs were about 2.5 times higher than if they had just one language. One language, please. In most of these countries where people buy products, the judges are not that knowledgeable. They do tend to enforce contracts. China actually is great at enforcing contracts. Last ranking done by the World Bank, they were like 5th in the world. They will enforce contracts, but if it's not in the contract, it doesn't exist. And I've already gave you one example, which is if you don't say, hey, you cannot make my products and sell them to other people all around the world, there's nothing that prohibits them from doing that. And in some countries, including China, it still makes sense to have your contract sealed or chopped. Next slide, please. Okay, the good contract is with the right party. If you're buying widgets from a company in China, do not contract with a company in Hong Kong. That company in Hong Kong probably consists of an office. It's almost certainly illegal because it's there as a tax dodge. And if something goes wrong with your products, you're going to end up having a cause of action against some company that has a chair and a computer, not a factory. So be careful. Very common. You see it with Hong Kong, you see it with Taiwan. You want the contract to be with the company that's actually making your widgets. Next slide, please. Okay, the good contract provides for liquidated damages. I've talked about that. It also provides for the right dispute resolution. Everyone thinks, wow, I'm in Portsmouth, Massachusetts. I want my litigation to be in Portsmouth, Massachusetts. No, you don't. Most of the time you don't. You've got a Chinese company or a Vietnamese company. They have no assets in the United States. You get a judgment in the United States. You take it over to China. They don't enforce it. You take it to Vietnam. They don't enforce it. You really need to think this through. A lot of lawyers think arbitration's the perfect solution. Sometimes it is. Sometimes it isn't. Next slide, please.
Oops, just a second here. Sorry. Sorry, how to get my way. There we go.
Okay, so Chinese courts are not obligated to enforce U.S. judgments, and they don't. Next slide, please. So I was giving a speech in Spain, and I realized, wait a second, I've got this U.S. example. I need to give a Spain example. So I called a Spanish lawyer, talked to him. He said there is a treaty between Spain and China where Chinese courts are obligated to enforce Spanish judgments, but they don't. Next slide, please. Most of these countries do not like foreign interference. So then people, what about arbitrating outside China, outside Vietnam? Yeah, that can work a lot of times. A lot of times it's not the best thing to do, but a lot of times it is. Hong Kong, Singapore, Vancouver, London, New York. But you need to know the rules of the country because China and a lot of countries do not recognize ad hoc arbitration. Meaning, so if you agree, hey, I'm going to have Ken Ross be my arbitrator in Minneapolis and just him without being part of AAA, let's say, they won't enforce it. But China is a member of the New York Convention. Most countries are a member of the New York Convention. So technically they're supposed to enforce arbitrations. They do most of the time, a lot of the time they don't. Next slide, please. And then you can go with CTAC, that's the main China arbitration body. It's actually a lot better than people think. We're doing a deal right now for a big US company, and we're specifying arbitration in Beijing in English with 2 foreign arbitrators, and it'll be a fair hearing. Next slide, please. Okay. I talked earlier about factory visits. As I said, I'm a big fan. Why? 1, they strengthen your relationship. 2, they help with quality assurance. You see what's going on. 3, it gives you a greater understanding of your production chain. I mean, we had a client go visit their factory in Taiwan, and they learned that literally nothing was being made in Taiwan. It was all being made in China and shipped to the United States, claimed to have been made in Taiwan, which could have gotten our client in a lot of trouble because they were effectively dodging the China tariffs. They fired that factory right away. And I guess that bleeds into the last one, which is ethical and customs protections. You can see if there's child labor. You can, not very easily because typically it's hidden, but you can do customs protections to see that they were not telling the truth, that their your factory in Vietnam, that the motor actually is made in China and not Vietnam or something. But there's always a lot to be gained by seeing your factory. Next slide, please. Okay, when it comes to good QC, just do it. Don't put it in your contract and not do it. This is, I guess, a good question for Ken, but we've always told our clients, look, if you say that you're in your contract that you're entitled to visit the factory once a quarter to check out QC, and you go 4 years without checking out QC, and then you get sued for product liability, I would think the plaintiff's lawyer is going to highlight the fact that you knew it made sense to visit every quarter and you never visited. And that helped to cause the problem. So let's not have any sympathy for this manufacturer. Ken, is that a valid concern or am I making that up?
Oh, sure.
Okay.
They'll try to show any deficiency in your process in the safety area to show that you're a bad company. But if you're not doing QC in China or in the factory in overseas, then you should be doing it on receipt of the product in your location, in your warehouse, or wherever it's going. So the fact that you're not doing it over there or not visiting the plant every quarter or whenever doesn't mean you can't do it. It just means that you've got to do it sometime. And that's why I say that if you're buying safety critical parts from a foreign country, either send people over there or have people there full time, which some companies do, or have ramped up enhanced quality control procedures on receipt and inspection of those products to be sure that they are what you ordered and they're safe.
Right. And there are a lot of very good QC companies based in China, based in Vietnam, based in Cambodia, and they're not very expensive. And you can use them, or you can use them as a supplement. But I remember in the early days of China, for medium-sized companies, they'd pay us a lot of money to protect their IP, to do all these contracts, and then we'd say, "What are you going to do by way of QC?" And they'd say, "Nothing. We don't want to spend the money." It really surprised me. So yeah, it is important. And the fact that Ken and I are saying that when this is not really what we do should really highlight that for you. Okay, next slide, please. That's it, everybody. Thank you. If you have any questions, feel free to ask them today or email me or whatever. And I'll now turn it back to Ken.
Thank you. I've got a few slides here and then we'll take questions. I've got some questions in queue there and we'll get to those. And I'm gonna assume you're going to look at this in more detail later, and I'll be posting an article I wrote a few years ago describing these things in more detail. These are sort of the additional questions you as product safety professionals want to think about when trying to decide, one, whether you're going to buy a product from an overseas manufacturer, or two, how important it is for you to enhance your procedures, enhance your contract, and get US based insurance from that company or something like that. So it's you can't always do it, and you may want to buy from a company. It's the only company you can buy from, and they won't give you the kind of good contractual protection that Dan is talking about. Well, then you've got to help the company decide, do we want to buy from that company or not? There are deal breakers, and it just depends on the situation. These are a bunch of, I'll say, deal breakers or deal makers, these few slides here. These are the things to think about. And one reason why lawyers always answer almost every question with, it depends, is because it depends. How much risk are you willing to assume or not? That's a business decision, not a legal decision. We as lawyers are trying to help you analyze the risk, analyze the ways you can minimize the risk, but whether or not you should force the company to have US-based insurance, or whether the indemnification they agree to is really going to be useful. These are things that we can help evaluate, but then you need to decide where you draw the line and where you're not going to deal with that company. So again, these are just a few things here or there. There's not all-inclusive list. And by the way, these questions, frankly, are the same as you'd have for a US supplier of a component or a US company you're buying from. It's just more important in an overseas manufacturer because you don't have access to them and language differences and things like that. So on the design side, do they do all the things that you think they should be doing, whether it's a finished product or a component in the safety area? You have extensive risk assessment procedures in your processes. Well, are your suppliers doing the same thing? Are their suppliers doing the same thing? Steve Jobs is quoted from a long time ago, obviously, as saying, I'm not concerned about my suppliers. I'm concerned about their suppliers. So, I mean, we've got multiple chains of people here. And Dan, we don't have time to get into contracts. Do you, as a purchaser of a component from a foreign country, do you analyze the contracts they have with their suppliers? Probably, I mean, now we're getting real granular here. So that's hard to do too. But we've got multiple entities involved in both raw materials, parts that go into a bigger part. You've got different parts being installed by different companies. So it can be a very complex process of manufacturing. So how involved do you get in the design of the product? I will tell you, as a legal matter, the more you get involved in the design of that product, the more liable you could be if there's a problem. If you're just buying a product off the shelf from China and they ship it to you and then you ship it to a retailer, we'll say, or you're the retailer and you receive it, there are certain defenses in some states allowing you to say that I had nothing to do with the product. I bought a box and I sold a box. I had nothing to do with it. Obviously, that's different if you are involved in the design and actually approve the design and provide the specifications. So there are questions about how much you want to get involved, and does that help make a safer product, or does that just unnecessarily enhance your potential liability if there's a problem? Manufacturing, similarly, how involved are you in that? Are you approving these things, how clear are they? Warnings and instructions, similarly, do you review the warnings and instructions provided by your component supplier or finished product supplier? And buying from China, they're usually going to be in poor English, in my experience. And do you suggest that they improve them? Or do you require them to go to competent people who advise on warnings and instructions to make good warnings and instructions? Or are you reviewing them and revising them yourself? And again, the more involved you are in that, if there are deficiencies later on, that makes you a little bit more liable than if you otherwise would. So it's a question to ask yourself. No clear answer one way or another. Post-sale area, real important. You're buying from a foreign company, and let's say they sell you a product that has various components in there. Are they selling that product or those components to other companies in the US? Are they instructed to tell you if they're having safety problems with the products they sell to other companies? Do they know anything about the CPSC? If you ask them, do you know what the CPSC stands for? And they say no, I'd have second thoughts about dealing with that company unless they confirm that they know what that agency is, know what the legal requirements are, and know when reporting and certain corrective actions are necessary. So in the post-sale area, you want to be informed of any problems they're having with any of the products they've sold you, wherever they're sold in the world. And so these are, again, things, and traceability also is part of the manufacturing process. Do they make them in a way that you can trace them and narrow the population? Documentation. We always have problems where they have good documents, but they're all in Chinese or some foreign language. and it's very costly to translate all those into English. So are they providing critical documents in English or not? Or are you going to undertake the responsibility to translate those to be sure that what they're documenting is adequate? And do they keep documents long enough so they are accessible and you can use them to defend a case or respond to the CPSC? And that, which of course could be years later. So what kind of documentation do they have of their safety processes, quality control processes? Do you see those? Of course, if they're in English, it's easier for you to then look at them. Do you review a risk assessment done by the foreign manufacturer and confirm that it was done adequately and written properly so you could use that document later if you need to? These are things to think about. You got to think about these things at the beginning of your relationship, not when the problems arise. At that point, it's too late. And then the last area and things that you can do, if you have a lawsuit, do they have people who can help defend you? They're the ones who designed the product. They're the ones who manufactured the product, we'll say. They're the ones who documented the process. Assuming that they even can't be sued in the US, will they send people over to the US to help defend you? And do they speak English? Doesn't absolutely have to speak English. We've had lots of foreign witnesses where we have translators, so that's okay. But will they cooperate and coordinate with your defense counsel and with you in defending a case if it involves their product? Now, if they indemnify you, Dan, you mentioned this earlier, if they indemnify you, are they going to take over the defense and do whatever they want? You don't want them to do that. Your name is out there. You're the US presence. So indemnification sounds great, except whether it's indemnification by an insurance company or by the manufacturer, you want to have some control and some involvement in that case. You want to participate in whether the case goes to trial or gets settled, what kind of documents are created, what kind of witnesses are provided, because your good name is out there, and the Chinese company or foreign company is less susceptible to reputational problems in the event something goes south during that case. Last thing, lawyers can be helpful. And this is the whole concept of prevention, is that we can help you prevent problems before they happen. Once they happen, that's when you get the litigators to help defend you. But and Dan is too, we're big advocates of trying to prevent the problems before they occur. And that's why we're doing these kinds of things. So first question is there is it a good idea to buy this particular component from a foreign supplier if it's safety critical? I've been doing seminars for 45 years. I can remember probably at least 40 years ago saying in seminars, and this was before China was the big supplier of products, don't buy safety critical parts from a company in Hong Kong. That's what I would say. Or at least have second thoughts about it, because it's going to be harder to defend and they may not be able to be sued. So I've thought this for many decades and have raised the issue of, is it a good idea or not? If it is a good idea, then yes, how do you protect yourself? And that's where we can help identify the options. Now, we can come up as lawyers with all kinds of good ideas, which may be impractical, and no Chinese supplier would ever agree to it. Well, then you got to decide what you want to do. Of course, the one decision is, well, don't buy this component from a foreign overseas supplier then, or make the component or the product yourself. So there are different ways to do this. So what we can do is help you figure out what the risks are and how to minimize it. Ultimately, it's a business decision about what you do, but that's a good start. And you don't want to enter into these kinds of relationships without understanding what risks you're assuming, because that's just not a good way, I think, to do business. And there are things that can be helpful and certainly different ways of doing it. So with that said, I'm going to stop and I've got some questions here, and let's see what I can get to here. We got 10 minutes, so I got some questions. All right. So one person said that you can check with the CPSC, who issues a letter of advice indicating previous safety problems from the supplier. Certainly, you can check the CPSC website to see if they show up in that website. I'm not that familiar with a letter of advice, but that doesn't mean it's not there. So yeah, there are ways to do Google searches, CPSC searches, litigation searches. There's litigation databases you can check to see whether that company's ever been sued. Of course, if they have no presence in the US, it's not going to help you. Next question. If you don't know the language, how do you find an interpreter who you can trust? I'll ask Dan that question.
Okay, well, one thing that I always want to be clear on is don't take a US contract and translate it into Chinese, because that's a complete waste of time. Because it's not the right contract. But when it comes to interpreter, I'm going to assume you mean someone who can help you communicate, let's say in China or in Vietnam with the factory. And this is a very good question. There is no great answer to it. Typically, I mean, our law firm has people we've known and trusted in Thailand, in Taiwan, in China, in Vietnam. But yeah, it is a problem. One of our lawyers used to, we still do. We work with a Polish guy in China whose Chinese is excellent. And we will also often have him go to the factory because they just assume he doesn't speak Chinese. And he hears all the things they're saying, like, hey, let's not show this idiot the back room where we're hiding the counterfeits or something like that. But yeah, no, there's no, you just have to find someone who you know and trust, and make sure maybe they have someone they know and trust.
Well, and let me say on that point, there are different ways that you can have different translations of the same words, having different translators translate it differently. And I've had problems with safety issues arising in foreign countries, and it's translated to something caught on fire, when in fact, and it was in Japanese, and in fact, that's not the way it should have been translated. I had different translators translating Japanese different ways. One said there was a fire, and the other one said it was overheating. So I don't know how you got to find good translators. I would just suggest, and I'm not an expert on this, that you find the translators are native language speakers, that they either are native Chinese, native Japanese, whatever language you're looking for, and they're not Americans who took foreign language in college. And so they know the language somewhat, but they don't know the local dialects in that country. And there are dialects from different parts of the country. So do your best, but you want to ask the translating company who these people are, what their background is, to try to indicate to try to show that they actually would know original language in that country, and not just something that they talk over here about. And the next question is on this point, and I'm not sure, Dan, if you said this, I don't remember you saying that a contract in Chinese brings clarity. So
I did say
you
that.
just said you shouldn't have it in Chinese. So I think you've already answered the question. Is that right?
No. I said that a contract in Chinese brings clarity. And the question is, can you clarify if a contract should be in one language? There was a prior comment that a contract in Chinese brings clarity. The clarification is that 99.9% of the contracts we do with China are in both Chinese and English. 100% of the ones we've done with Vietnam have been in Vietnamese and in English. But we only have one official language for that contract. And so typically our Chinese contracts, the official language is Chinese, because most of the time, surprisingly enough, the best solution in terms of dispute resolution is a Chinese court. But we also have it in English. But what we always tell our clients is we do the contract in English first, we get our client's approval, and then we rewrite it in Chinese. We have a Chinese lawyer in our office write the contract in Chinese, then one of our American lawyers who's fluent in Chinese looks at it. And I always say rewrite, because you don't translate, you rewrite, because as Ken points out, one word can mean two different things, but also the contract needs to be written like a Chinese contract, not like a translated US contract, or not like a translated English contract, because we write it in English for China, but then it needs to be rewritten in China, in Chinese for China, using the key Chinese buzzwords.
Okay, next question. If you're doing testing or QC by a third party, should you have the third party travel to the factory to select samples, or can you just have the samples sent over here? And that's kind of a quality control question, I guess.
Well, and I think we all know the answer is better. It's better if they go to the factory, but it may not make economic sense. Uh-oh, I think Ken has frozen. Can everyone hear me? Raise your hand if you can hear me.
We can hear you, Dan.
Okay, good. Okay, so I'm just going to keep pushing forward here with the rest.
Testing laboratory. Sorry, Dan, you were frozen there for a second.
Oh, you were frozen too. I think we both were.
Okay,
Okay.
Sorry. Well,
all right.
Well, anyway, what I thought I was saying, I don't know if anybody heard it, is that of course you should go to have the lab, possibly people in China going to the factory to see the samples, because they can view the manufacturing process and see who's doing it. So seeing the product itself, the sample in the context of the manufacturing plant, I think is much better. Now, with that said, we've had problems over the years with the third-party labs being bribed by the Chinese manufacturer. And I think those entities that have suffered that problem have cleaned that up, and it's less prevalent. But in years past, the testing labs were being bribed to sort of put the stamp of approval on that Chinese product when in fact it didn't deserve that.
Okay, I'm going to jump in here, Ken, and pull the last two questions for the final 3 minutes, if I could. So here's
see those. Yeah, go ahead. Right ahead.
Okay, it says we use the UL and TUV client portals to check on standards compliance. That is a good idea, because it is not uncommon for Chinese companies to use fake UL numbers. In fact, we were recently involved in a lawsuit in Houston where that was claimed. And then the last question is, what is the link to the website where you can check if the company has been taken to court? And the answer to that, and I'm delighted to give the answer because it shows how incredibly difficult it is to do business with China these days. The answer is there's no one website. There are a couple of them. They're Chinese government websites, and very few people can get on them. Very few people know how to get on them. What we have to do is we have to have a Chinese citizen, preferably a lawyer, do it from the United States using a VPN so that they look like they are in China. If you are outside of China, you cannot get access to them. And if you're not a Chinese citizen, you cannot get access to them. So, and they're in Chinese. So if you can figure out how to do all those things, let me know, and I will get you the links. I don't have them in front of me.
Okay, well, the last slide here is for, if we didn't answer your question or you have additional questions, you can email us. Look at the material that we're going to post later today or tomorrow, and let us know if you have more questions. We appreciate everybody attending today. It's right on the hour. Thank you, Dan, very much for your participation. Hopefully we've answered more questions than raised questions, but this certainly falls into the category of you can't analyze the risks unless you know what the risks are. So I think what we've talked today about the risks that are there, the things you should think about, but how you analyze them and how you then make that decision about what to do is complex, and there's no right or wrong answer. There's an answer that should match hopefully your acceptability of risk by buying and selling certain products made overseas. And that's the best we can do in helping you analyze this. But let us know if you have any questions. And again, thank you all very much. Thank you, Dan, for being here today. And we wish you all a good day today. Thank you.
Thank you for having me.